republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I have some just housekeeping amendments or announcements. As you know, we're here as guests of the First District Court of Appeal. They've graciously allowed us to use their facilities, and so we want to respect their rules, which say that no food or beverage other than water is allowed in this room. Please take this opportunity to silence your cell phones. Anyone addressing the commission, please speak up so that our recording equipment can pick you up properly, and likewise for commissioners, make sure that you speak into the microphone for preservation of the record. I ask everyone to be as brief and concise as possible with your questions and comments, as we have a number of items for consideration today. Pursuant to Florida Statute Section 286.0114, members of the public have the opportunity to input on matters before the commission other than cases in which we act as a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard in this matter, please fill out a speaker card and give it to Mrs. Fulford, who is waving her hand in the back of the room. Do I hear a motion that we approve the minutes of our session of December 2nd?
So moved.
Second.
All in favor say aye.
Aye.
Opposed, like sign. Okay, our first order of business is item 4, consideration of federal action on a stipulation. We have before us a proposed settlement in complaints number 21039 et al. That have been consolidated in regard to Vanessa Bow. Will the parties please identify themselves for the record?
Jim Moore from Bear Robinson, along with Commissioner Ball.
Okay. Is there anyone else here on this case? This is a case, ladies and gentlemen, where probable cause was previously found, and the parties, rather than taking it to the trial level, have come to an agreement and have engaged in a joint stipulation between the commission advocate and the respondent. After we consider all the materials and the presentations, the commission may vote to either approve or reject the stipulation. If the stipulation is rejected, the parties cannot renegotiate and present a new stipulation at this meeting, and the complaint would go to the Division of Administrative Hearings for an evidentiary hearing, and the parties would be able to negotiate there if they wanted to, and then it would come back to a future commission meeting. Complainants have the right to respond in writing to proposed stipulations. 2 complaints were filed in a response to stipulation, and those responses are in your meeting materials. Mrs. Miller is the advocate on this commission, and you are hereby recognized.
Thank you. Good morning, Commissioners. Elizabeth Miller. The respondent in this case abused her office when she organized a vaccine pop-up clinic in Lakewood Ranch that only catered to residents who lived in the 2 zip codes that encompass that community. And also she placed her name on a so-called VIP list along with 4 other individuals to ensure that they received the vaccine at that same time when the vaccine was still a very limited resource. Respondent maintains that she did not receive the vaccine. However, that fact is irrelevant in this case. She chose not to receive it after the public uproar. Before you is a joint stipulation entered into by the parties. In it, the respondent admits the violation. She admits that while she was a public officer, she used or attempted to use her official position to secure a special privilege or benefit for herself and others. Also, she admits that her actions were corrupt. I'd like to address a few of the complainants, or at least one of the complainants' concerns in this case. The complainant would like the agreement to require that respondent personally pay the penalty. The executive order that the governor will issue imposing the penalty will specifically state, and I quote, "Payment must be submitted with a written statement under oath by respondent's name, Vanessa Baugh, that the penalty amount was not paid with public funds and will not be reimbursed with public funds," end quote. The advocates prepare that affidavit, and we require it when payment is made. Another concern, valid concern of at least one of the complainants, he would like to see the agreement state respondent will personally pay her legal fees and travel expenses. And even though we recognize that that's a legitimate concern, the commission's hands are tied in this matter. The commission is without jurisdiction, and no respondent may voluntarily or involuntarily enter into a stipulation or settlement which imposes any penalty, including but not limited to a sanction or admonition or any other penalty not contained in the particular statute that sets forth the penalties. The items the items that complainant requests be in the settlement are not sanctions stated in the law. I think this is a fair and just result for the following reasons. We negotiated the settlement in good faith. It's an admission of guilt with a known sanction. By her signature on the document, she is admitting responsibility and that her actions were corrupt. And additionally, as you all know, the Court of Public Opinion delivers reputational justice. And a reputation is a commodity. The loss of a good reputation is a penalty. And that penalty has also been imposed upon this respondent. From the state's point of view, this is the best use of its resources. If we go to DOA, we have no guarantee that the judge will find a violation. Here we have a guaranteed result, and the parties ask that you adopt the stipulation. Thank you.
All right, thank you, Ms. Miller. Are there questions from members?
I have a disclosure.
Yes, sir.
Chair. Is the mic on? They're on. I was the state representative for District 70, which included Manatee, Sarasota, Pinellas, and Hillsborough. And I know the Commissioner Vaughn, but I will not impede my judgment on this case.
Okay. Are there other questions or comments? Thank you, Ms. Miller. Sir, do you wish to make a response?
Yes, sir. Thank you all. I'm Tim Moore. I'm joined here by Commissioner Baugh. Unfortunately, my law partner, George Levesque, is unable to attend today due to a family medical situation, but I'll be brief. First, I'd like to thank the Commission for considering the stipulated settlement. Second, I can assure you that we've taken this process very seriously and the complaints very seriously, and Commissioner Baugh has, the process has affected Commissioner Baugh in the way she runs public office in a positive way. Commissioner Baugh has acknowledged she's made a mistake and that if she could do it again, she would do it differently. There was a suggestion that by one of the complainants that $8,000 was not enough of a fine. In addition to the $8,000 fine, Ms. Baugh has incurred substantial legal fees to date, and it's my understanding that under a settlement, those would not be recouped from the county. So there's that penalty as well. In an effort to resolve these complaints, Commissioner Baugh would like to enter into a settlement agreement admitting violation, paying a fine, and receiving a public reprimand. And we thank the Commission for your consideration.
Are there questions from members of the commission? Thank you, sir. All right.
And
Yes, yes, sir.
if it would please the panel, Commissioner Baugh would like to say just a few words.
Certainly. Commissioner?
Thank you for letting me speak, Commissioners. This has been a major experience for me, one that I've learned a lot from. It's been a tough experience for Manatee County. I always have tried to be a good commissioner, always. So from that standpoint, I just hope that you will agree to this agreement. I will do my best possible, everything that I can, to be the best commissioner, to make this commission proud in the future. I want to tell you that as far as attorney's fees and the fine, the county has not paid any of the fees on this. I've paid for all of it, my husband and I. We will continue to do so. I wouldn't even consider taking this to Manatee County for payment. So I just appreciate you hearing us out. I appreciate you looking at the agreement. And I do hope that you will take my apologies for this, for even having to be here today. So thank you.
I have a question, Mr. Chairman.
Thank you, Commissioner. The question, Commissioner
Yes.
Newton.
Yes, I have a question, please, of the Commissioner. I keep hearing over and over that the $8,000 fine and the legal fees are something that you guys, it's a hardship for you guys because you have to pay it. Do you think that anyone else should be responsible for this since it's what you done?
No, sir, I don't think anyone else should. You know, it's my responsibility.
And my
I've
other
taken
question
that
is,
responsibility.
with the vaccine being in limited supply and the governor mandating that it's 65 and up community, which is a high-risk community, and people with high risks like diabetes and different ailments get the vaccine first, do you know of how many people in that district or in my district or in Manatee County that passed away during these shenanigans when they could not get the vaccine?
I did know, in all honesty, Commissioner. I do not recall. I don't want to say something that's not accurate. So I can't tell you how many passed away. I can tell you that I lost 5 friends, you know, to COVID when it was at its height. In Manatee County, it was very, very tough. I had 7,200 that were 65 or over just in my district, in Lakewood Ranch. So we certainly had quite a few, and it was a very hard time for all of us, all the commissioners and citizens. I will tell you that in trying to make sure that we tried to get everybody covered that we possibly could as quickly as we could was what we were essentially trying to do.
And I know it's beating, Mr. Chair, I know it's beating a dead horse, but with the vaccine being limited supplies and none of the elected officials able to get, not even me or the governor, I think could get the vaccine. It was for people that was, because I'm not 65, and they had inherent health hardships. Do you think it was fair for you to be included in that list of all those individuals in that district when they installed public trust in you in that office?
In all fairness, Commissioner, I made a mistake, which I wholeheartedly understand. And I don't, you know, the thing of it was that I was asked to have a vaccine clinic in Lakewood Ranch. The vaccines did not come from Manatee County. They came from the state. Again, I realized that it shouldn't have probably happened the way it did, but I was doing what I thought at the time was the right thing to do. You know, I think it's fair to say that, at least for myself, you know, this pandemic was very tough on all local governments. We were trying everything we could to get people vaccinated as soon as possible. You know, and I was asked to, what I thought was appropriate to have one in Lakewood Ranch. The state was bringing in the vaccines. I tried to do what I thought was right. It was a holiday weekend when it all came about, and I see that now that was a mistake. I should have, you know, contacted the board and worked with them more closely, and we did have a lottery system in Manatee at the time. So I take responsibility for that, Commissioner.
And my last question is, Manatee County is a big county, and I represent some of the most socioeconomically disadvantaged, challenged individuals down in that county. Why not do the pop-up vaccine clinic in one of those areas?
I will tell you that actually there had been clinics, vaccine clinics, in other areas of Manatee County that was not in the 6,000 doses that Manatee was receiving. Extra vaccines had been brought in the past. And as I said, I was asked to have one in my district, so that's what I did. looking back on it, of course, I can see where maybe it wasn't the right thing to do. I can't deny that, nor will I even try. So, you know, it was, I think all of us at the time were trying to get our people vaccinated as quickly as we could.
What rationale went into the zip code? Was that one of the socioeconomically challenged zip codes in Manatee County?
No, sir, it's not. It's, what happened was I was asked to have a vaccine clinic in Lakewood Ranch, and those two zip codes were the zip codes for Lakewood Ranch.
Is that an affluent area? Is that an underserved area? What
I'm
is
sorry, I
Lakewood Ranch?
couldn't.
What is Lakewood Ranch? Is it an affluent area? Is it an underserved area? Could you tell us?
Well, we have a little of both. I mean, it's not just affluent, no. We have different, you know, people that live there. It's not all country club living in Lakewood Ranch, no.
Thank you, Mr. Chair.
Commissioner Akers?
Thank you. Thank you, Mr. Moore, for standing in for Mr. Levesque. And I don't envy you, but hope that you might know the answer to the question with respect to paragraph 6 of the joint stipulation. And that is the one that begins with the respondent denies allegation 1 as it pertains to the disproportionate benefit, but you are ready to move forward. For purposes of negotiation, the advocate agreed to accept that. But I am curious if you can explain, it would make me more comfortable with a joint stipulation if I understood the basis for distinguishing that one from allegation 2, although I understand factually it may have been subsumed
Correct.
within it. It still seems like to deny it, I'd be more comfortable if it was admitted and we still came up with the same conclusion with respect to the fine and the penalty.
Yes, thank you for the question, Commissioner. As you noted, factually it is subsumed within allegation 2. But if we look at just the facts for allegation number 1 on the constitutional amendment, it is whether or not Commissioner Ball received a disproportionate benefit. And she never received the shot. All 3,200 shots were given to individuals over the age of 65. So no one was deprived a shot because Commissioner Ball wanted to be on the lottery list. And you know, there's been suggestion of a VIP list, but I think the email traffic back and forth with the commissioner and the director of public safety indicates that the commissioner wanted to make sure, since she lives in the zip code, one of the 2 zip codes where the governor wanted to have the pop-up clinic, and she's over the age of 65, she wanted to make sure that her name was among the 7,000 from which the 3,000 would be chosen from. So, you know, she didn't ask for any special treatment. She wanted to be among the 7,000 where the governor wanted to have the pop-up clinic. Manatee County at the time was 22% senior vaccination rate. That was the second lowest of anywhere in the state. After the pop-up clinic, a week after, they'd surged to 35%. So the fact that Commissioner Ball never expressly said, I want to make sure, Jacob Sauer, that I get a shot. She said, I'm in the zip code. I'd like to see my name on this list. It was a holiday weekend. She was looking at 7,000 names on an Excel file on her phone. And at the end of the day, she never received the shot. And she was eligible under the governor's order, over the age of 65. Does that answer?
It's your best answer. I mean, I understand. I mean, I think it's arguable that there's still a disproportionate benefit simply by being on the list, but I understand your position.
Further, Commissioner Newton?
I have a question for the attorney. So it is her, in the joint stipulation, it's her commitment that this was all her fault and she confessed to doing all this. However, to that one count, she's saying that there was no benefit. Let me ask you, was there any other elected official name on that list from Manatee County?
I'm not sure, Your Honor.
Were there any other commissioners from Manatee County on that list?
I do not know.
Can I put that to the commissioner?
Yeah.
Was there any other commissioners' names from Manatee County commissioners
Commissioner
on that
Newton,
list?
no, there was not.
Was there any other elected officials in Manatee County on that list?
I don't believe so, no. May I?
Just one more question for the
Yes, sir.
attorney. So, my job as elected official, I am entrusted with the public trust, and I get valuable information that no one else can get. No one. So Joe Public could not get on that list. The only reason the commissioner name was on that list because she put it on there, and because she was a county commission elected official privileged to that information. That's the only reason. Sir, that is a benefit, whether you get a shot or not. People died. That was my most, I kept track of every district in my newsletter and the fatalities from COVID. Manatee County was the highest. That's why I asked those questions. It wasn't trickery, but for you to sit here and say that it was not a benefit, and her to say they don't want to admit to that part, I got a major problem with that. And so there's a lot of people back there in that area. That's what I'm saying. I mean, you can code it any way you want, but for her being a county commissioner, an elected official with public trust, she would have never got on that list unless she won it in the lottery.
Mr. Chairman,
Commissioner Gates?
thank you. I'd like to associate myself with Commissioner Anker's question and her comments. Of course, anyone who comes before any judicial or quasi-judicial body and admits wrong can go back home and place whatever kind of construction on that they want for their constituents. And that's your privilege. But I hope that, that in the construction that you place on our decision, whatever it might be, in your interpretation that you make of our decision back home, I hope you show the same acknowledgement of wrongdoing and contrition that you've shown here. Our decision here isn't based on news reports, but it is disconcerting to read the news reports from your area in which you sort of blithely dismiss the importance of this and don't really say that you did anything wrong, or you begin to talk about sort of extraneous issues. The fact is that you put your name on the list, and the only reason you didn't get the shot was because there was a public outcry, as the commission advocate indicated, and that's unacceptable in a public official. Leaders sleep on the ground. They don't sleep in a feather bed. When their constituents or their followers or their folks have to sleep on the ground. You sleep on the ground too, and you didn't. You tried to get a benefit for yourself, and you would have gotten it but for the public outcry. So when you go home, if you want my vote today, when you go home, please don't try to smooth over this and place a improper construction on what occurred today. Please go home and say and do what you've said and done today, and that is to admit that you were wrong, admit that you violated the code of ethics, and show contrition.
All right, further comments? Do I hear a motion for adoption of the stipulation?
No, I have a question,
Oh, I'm sorry.
Mr.
Commissioner.
Chairman. And this is for our advocate, please. Under our rules and laws, is this the maximum penalty allowed?
Through the chair. No, sir. Maximum penalty per allegation is $10,000 or removal from office. And with the two allegations, it would be $20,000 as the maximum penalty or removal from office.
Help me understand why you felt that this was the best offer available for, why is this the best offer?
It was a negotiated plea. It was something that we knew we would get an admission of guilt for a violation, as opposed to going to DOA and possibly not winning a violation. Also, it was anticipated it'd be about a 3-day hearing, and for the resources expended on that, this seemed like the best deal.
Okay. Thank you.
Further questions? Now do I hear a
Move
motion?
approval of the recommended order.
I'm sorry.
Move approval of the recommended order.
And I second, Mr. Chairman.
Second. Any discussion? Commissioner Newton?
I think this is, to me personally, it's a travesty. I mean, it's clear what went on here. This was not a mistake. This was not a Form 6 accident. It was deliberate and calculated and pointed. And for $8,000, I think it's, you know, for the people back in Manatee County, I think it's a travesty where I represented. I know you guys read reports. I lived it. I lived it. Every month, every person, everybody. I was down there with the governor, opening up testing sites. I was down there trying to get vaccinations for all these people that were dying. I heard about people not being able to get it because they looked like me. I heard it's just, I don't know, it brings back too much pain to myself. So I know what it's doing to the people back home. It's easy to sit here and say, we read articles and we don't know what's going on. We know, and it's obvious. And to our advocate, there's no way. Of all the cases I heard since I've been sitting up here, this is a slam dunk. Ray Charles can see what went on here. I don't understand it. I do not. And for $8 grand, making a deal so we don't go forth and hear entirely what went on and let them confess to some things but not all. If you're guilty of all of it, not some of it, not part of it. That's my problem. And I will not be supporting this at all.
Further discussion.
Mr. Chairman,
Commissioner Gates.
I seconded the motion to adopt the settlement, not because I think it's the best we could do, and I would agree if you can't win this one at DOA, we probably shouldn't go to DOA on anything, but I also believe that the advocate has acted in good faith, and my hope is that the commissioner will, first of all, will suffer the reputational penalty, and secondly, that she will understand and place the proper construction and representation on this settlement if it's agreed to today. I'm reluctant. I believe we could have. I believe this is a case where we should have gone to the maximum penalty. How do you go to the legislature and say we want our penalties raised if a case like this only gets to $8,000? But I also have confidence in the advocate, and it is with reluctance that I will support this motion. But I do believe that I'll vote for it.
Further comments? Commissioner?
Mr. Chairman, the only thing I can really add is based on my experience in my prior employment as prosecutor. Plea negotiations, which is what this is, seldom left both sides totally happy with what the end result was. For a lot of the reasons that have been itemized, I am not totally happy with it. However, it does seem like an appropriate resolution acknowledging that this lady, more than criminal defendants ever would, is going to have to answer to the court of public opinion in her home circuit when this is all said and done too.
Further comments? All in favor of the motion, say aye.
Aye.
Opposed, like sign.
Nay.
No.
I think there were 2 negative votes, but it passes. Thank you. Okay, our next item is item 5, consideration of final action on advocate's motion. This is in complaint number 20-063, Homer Bradley Harvey. It's before us on a final hearing because it appears that there are no disputed facts. The complaint had been referred to DOA for hearing, but the administrative law judge sent it back to us after the respondent did not dispute the facts set out in the advocate's request for recommendations. We have a copy of the file as well as a draft order prepared by our staff and the advocate's motion. Would the parties please identify themselves? Anyone here on this matter? None appearing. Ms. Miller, you are recognized. We're conducting this pursuant to sections 120.569 and 120.57.2 and Rule Chapter 28.106 of the Florida Administrative Code. At this hearing, we'll receive any disputed issues of law. If a violation is found based on the facts submitted, then we'll determine what penalty is appropriate. Both parties will have an opportunity to present to the commission any oral or written evidence relating to the complaint. Each party would normally be given 10 minutes, but no one's here for the respondent, so Ms. Miller, you're recognized.
Thank you. Commissioners, very briefly, this respondent failed to participate in any of the proceedings, and we won at DOA by default. I'm asking you for the relief set forth in paragraph 4 of my motion, along with with that as a recommendation of a total civil penalty of $40,000 and total restitution of $209,236.30. And I ask that you
Which one got continued?
find that he violated the statutes. Thank you.
Okay. Do I hear questions or comments from commissioners? Sir?
Just a question I had when I first read through this, has there been any criminal charges filed in this case?
Through the chair, yes, sir, there is a pending criminal case, and as of yesterday, they were still taking depositions.
What were the charges? Have there been charges made, or
I beg your pardon?
have there been criminal charges made?
Oh, yes, sir, there are criminal charges.
And what are those?
I'm sorry, I don't specifically recall. I'm sure one of them was fraud, but I'm sorry, I don't recall. There are several allegations, though, or counts.
Further questions or comments? Commissioner Meigs?
You didn't say it, but it seems like I wrote in my notes from my review, is he removed from office now, obviously?
Yes, sir, he was removed by the governor, suspended by the governor.
Suspended, but this order will cause him to be removed from office? Just suspended?
I believe he was only suspended, but I'm pretty sure he'll be removed once he's convicted, and I think he'll probably be convicted, if he hasn't been removed now.
But we're not recommending removal.
Correct.
Okay. Further questions? Do I hear a motion?
I would move to adopt the recommended order.
Second.
It's been moved and seconded. Any discussion or questions by the commissioners?
Question to Commissioner's point, can we not recommend that he be removed from office as part of our recommendation? Is that not within our purview?
Steve? Or
My understanding is, based on the executive orders, I think he's only been suspended from office, so you can recommend the removal.
We can. Well, I, for one, would sure like to see that in the recommendation.
Well, I suppose you could make a motion to amend.
So moved.
Second.
Okay.
I agree.
All right. Further discussion? All in favor, say aye.
Aye.
All opposed, say nay. Okay, we have an amended motion before us. All in favor of the amended motion, say aye.
Aye.
Opposed, like sign. Shown adopted. Thank you, Ms. Miller. The next item on the agenda is the consideration of advisory opinions. We have two before us. However, for good reason, I have granted a continuance of file number 2794. So that leaves us with file 2793, conflict of interest, member of the city commission entering into contractual relationships with city to receive property improvement program funds. Gray, you're recognized.
Thank you, Chair. This opinion, excuse me, this opinion request has been made by the city attorney for Margate, who's inquiring on behalf of the city commissioner. And as the chair just said in a nutshell, the commissioner is wondering if she can participate in a property improvement program that was recently started by the city. Now, I'd like to fill you out of the background of that program first, just to give you some context before I move on and discuss the ethics statute involved here. Apparently what's happened is that the city has voted to receive some federal funds pursuant to the American Rescue Plan Act and has decided to allocate a portion of those funds, about $1.5 million, towards starting this property improvement program. Under the program, property owners in the city, both residential and commercial, can apply to have the city reimburse them for certain eligible improvements they make to their property. The process is that property owners thinking about making improvements will submit an application to the city. The city will review it, and in the event that it's approved, the property owners will go out and, using their own personal funds, hire contractors and workers to make these improvements to their properties. Once the improvements are done, they then submit their receipts and some documentation to the city, and the city then reimburses them for their expenses. I think under the program, residential homesteaded property owners can receive a 50% reimbursement for eligible improvements they make, up to $10,000. There's a couple other things I want to note about the program. First, from what we've been told, it is open to all property owners within the city, both residential and commercial. It's not restricted to only certain sections of the city or certain types of property. Anyone may apply. Second, while the City Commission did approve the program and allocated funds towards it, the program, from what we've been told, was by and large developed by the city manager's office. The city manager put the program together. He did present to the City Commission for their feedback, but this is more or less the program the city manager designed. And that leads me to my third point, which is that the city manager and his staff alone review and approve the applications and oversee disbursements of funds under the program. The City Commission is not involved in that process, and we've been told the applications are reviewed first come, first serve. And fourth and finally, the approval of the applications is automatic as long as the improvements fall within the program's criteria. The city attorney wrote us that, and this is a quote, "The city has no intention of denying any applicant of any funds if they meet the program's criteria." So the key points to keep in mind here are that this is a city program open to every property owner in the city. It's overseen solely by the city manager. The City Commission has no role in the process. And the approval of the application seems to be automatic as long as it's for eligible improvements. I'm going to be circling back around those points in just a minute. But turning to our laws here, what the City Commissioner would like to do is to receive reimbursement funding through the program. From what we've been told, she hasn't yet made the improvements to her property, but she has submitted an application which the city is waiting to review until she gets an opinion from the Ethics Commission on whether it would be a prohibited conflict of interest for her to receive funding. Now, the law in question here seems to be Section 112.313, subsection 7A, in particular the first part of it, which, as you know, is triggered if a public officer like a city commissioner has a contractual relationship with a business entity or an agency being regulated by her own agency. Now, as you can see in the draft in front of you, I think the situation being presented here mechanically meets the elements of the first part of that statute. First of all, I think there's a contractual relationship. If the commissioner's application is approved, I think she'll have a contractual relationship with the city manager's office. That office on its own is going to be promising that the city will be reimbursing her for the funds that she expends in making eligible improvements to her property. And she'll be relying on that promise. It will be inducing her to go out and hire contractors and workers to make these improvements. So if the city then reneges and refuses to provide her with funds, I think that she'd have legal grounds to demand that it provide her with those funds. So I believe she will have a contractual relationship with the city manager's office, which will be approving the application. Also, the city manager's office is subject to the regulation of her agency, the City Commission, because the City Commission oversees the city manager's office. So again, mechanically speaking, in the event that her application is approved, I think she'll have a contractual relationship with an agency being regulated by her agency, the City Commission, and that mechanically meets the elements of the first part of the statute. Now, this type of situation doesn't come up all that often, where you have a member of a governing board applying to a subordinate office for funding, but it has happened before, and the draft cites a few opinions in which the Commission has found this part of the statute to be applicable in these types of circumstances. Because of the regulatory oversight the governing board has over the subordinate unit, the Commission has found this technically presents a conflict under the first part of the statute. But now I want to circle back around to those points that I emphasized earlier. The City Commission is not involved in reviewing, approving, or paying these reimbursement funds, and the program is set up to automatically disperse the funds as long as the improvements are eligible under the program's criteria. Now, there's a law in the Code of Ethics, Section 112.316, which says essentially that the code is not intended to prevent a public officer from following any pursuit as long as it doesn't interfere with a full and faithful discharge of their public duties. In the past, the Commission has applied this law, Section 112.316, to negate a mechanical application of the first part of Section 112.313, subsection 7A, when the public officer involved plays no role in the performance of the contract with their agency. Now here, the City Commission has a non-existent role in the property improvement program. And as I've already explained, the award of funds through the program appears to be automatic as long as the improvements in question are eligible. So under these very unique facts, I would recommend that you apply Section 112.316 to negate the mechanical application of Section 112.313 subsection 7A. Again, the City Commission is involved in this process, and there's really nothing that she can do in her public position to move the needle on her application towards having it approved. It's going to be approved as long as it concerns an eligible improvement. Of course, the opinion does warn her not to use her public position to expedite the review of her application. That conduct could trigger the misuse of public position statute, could trigger the constitutional prohibition against abusing your office to get a disproportionate benefit. And this opinion in no way prevents the Ethics Commission from investigating or finding a violation of that kind of misconduct. But the very narrow question here is just whether she can participate in the program. And the opinion in front of you recommends you do apply Section 112.316 to negate the mechanical application of Section 112.313 subsection 7A and allow her to receive these funds. I offer the draft now for your review and approval, hopefully. I'm happy to answer your questions. I will say that Mr. Tulsis, the city attorney, is here, and Mr. Curtis, the city manager from Margate, is here as well. I don't believe they have anything to address unless you have questions for them. But I wanted to make sure that you knew they were here in case you have questions that you think they might be better equipped to answer.
Thank you, Gray, and I neglected to ask if anyone was here, and I appreciate your introducing them. Would either of you gentlemen like to say anything?
Good morning, Mr. Chair and Commissioners. David Tulsis, interim city attorney for the city of Margate. With me today is Cale Curtis, city manager. Just like to thank you for your consideration. We agree with the draft opinion, and we're happy to answer any questions that you might have today. Thank you.
Are there questions of the commission? Sir?
What is the relationship between the city manager and the city commission there? Is he hired by the city commission?
Yes.
My issue with this one is on page 11 where it says programs designed to automatically accommodate all eligible applicants. Is there not a funding limitation on the program? What, was it $1.5 million or whatever? How much money is placed in the program?
If I might, yeah, the city commission allocated $1.5 million to the program.
What would be the process if the applications for receipt through this program exceeded $1.5 million? I'm thinking about the first case we had today where how do you get on the list and who places you on the list?
Right.
What would be the process there for determining whether or not the city commissioner was high on the list or just happened to fall somewhere and you got down to where you ran out of money?
First, with respect to the funding allocation issue, if they reach that limit of $1.5 million, the city commission would have to consider whether or not they wanted to allocate any additional funds. So it would have to come back to the commission. All right?
Doesn't really address the question. Where would that commissioner be on the list, and how would she be placed there? Is it time-stamped based on your application, or I'm just curious how that funding allocation would occur?
I mean, the city manager can answer the process, but it's my understanding the applications are submitted electronically. They're considered as they are submitted, and then the funding is allocated as the receipts are submitted, and the individuals then qualify for the reimbursement.
Further questions?
Mr. Chairman.
Commissioner Gates.
Thank you, Mr. Chairman. A question for our general counsel, please. I recall that we had an opinion before us some time ago having to do with a water issue, I think, where there was a water board, and I'm not recalling the precise honoraria and who did what to whom, but I think there was a member of a board who also wanted to benefit. The argument there was, as I recall, that there would be no limit to the funding. Somehow I found that to be an extraordinary contention, but it was the contention that was made nonetheless. And And my understanding is, please correct me if I'm wrong, that one of the reasons that the commission agreed to that advisory opinion was because there literally was no way that anybody could be told no. That there was sufficient funding for everybody who was in that district. Is there a difference, therefore, between that case and this case, or do I not remember the details of that other case very well?
We're both prepared to answer that question. Ray looks like he's got it, but I can add anything that.
Yeah,
we're both
either one of you,
prepared to
please,
answer.
sir.
I think that Steve wrote that opinion, so if I goof this up, he can hopefully jump in.
That's why I asked Steve.
Yeah. I think the two opinions are very similar, Commissioner. I think here you do have a finite funding. Only $1.5 million have been allocated towards this, and as you just heard from the city attorney, it's not clear if the city's going to continue the program once that's depleted. But that being said, I think the similarities ring true in that the granting of the applications here are automatic, just like in that other opinion. And also, I'm not sure if there was any discretionary factors to consider in that other opinion or not, but in this particular instance, there is no discretionary criteria the city manager's office is going to weigh when it's looking at these applications. In response to Commissioner Moore's point, these are just going to be reviewed first come, first serve, and then they are automatically approved as long as the improvements are eligible. One more thing that I think might correlate this to the opinion that you're asking about, Commissioner Gates, is that I think in both of these instances, the program was equally open to everyone in the political subdivision. And so that kind of reduces the risk of any type of unfair or biased treatment, because everybody has the same opportunity as a city commissioner to apply for funding through the program.
May I follow up, Mr. Chairman?
Yes.
But that, with all respect, I don't know that that answers Commissioner Moore's point. As I took his point, it had to do with the fact that here we have a program where there is limited funding. And unless the city were to decide that when the federal funds were finished, that there would be more funding, which is a huge assumption for us to make, and no one can really know whether that would be true. Isn't that the essential difference between these two situations? That in one case, there was no way in which, given the very limited number of people who were in that water management district, that there would be any way that the funding could run out. And here, arguably, the funding could run out, and Commissioner Moore is asking, does the city commissioner arrive before the funding? Does her application arrive before the funding runs out? The answer, I think, to that question is yes, and therefore, is it proper? And here I would like to hear from our general counsel.
One thing that we didn't do in that other opinion was we didn't apply the exception that Gray is recommending in this proposal here. He's recommending that we apply section 112.316 to operate to negate the conflict of interest because the officer serves no public role in the execution of this program. We didn't do that in this other opinion here, and I'm looking for the exact language in it now. I've got the opinion up here, but we didn't do that in this other one because, and my memory of it is, the board had a little bit of involvement in it. And so that's different than here where the city commission has no role in, or no discretion to execute. I'm looking for the language in this other opinion, but my memory of it was the board was a little bit involved in the program.
Mr.
Because
Chairman?
the board set up the program. For example, they set up the criteria for how much the reimbursement could be. They set up the length of it. They set up there were terms of the program that the board in this one set up. So they had a role in setting up the program. That's all that's been done here. My understanding is they allocated funds in the opinion that's before you.
Mr. Chairman?
Thanks, sir.
But isn't it the case, Mr. General Counsel, that we agreed to that other opinion? Did we not? Did we not say that in that case that you're describing, that the commission agreed to an advisory opinion that said that it was all right for the member of the water board to participate in the water management district benefit? but it was on the strength, at least my vote, was on the strength of the fact that there were a limited number of people who could, because there were a limited number of people in that geography or that political subdivision, and there was enough money to go all the way around. It was on the strength of that that I voted yes for the other opinion. That's the difference, in my view, between that opinion and the proposed opinion. And I'm sorry, I'm the victim of the last case, and I can't help it being the victim of the last case, but I'm concerned that in a circumstance in which there is a specific and declared limit on the funding, and arguably there could be more demand than there is supply for the money over time. I'm concerned about city commissioners who hire, by the testimony given today, the city manager administering, as I'm sure he does in a proper fashion, this fund, but yet a city commissioner shows up on the list. And there's gonna be somebody who's gonna be the 1.5 million, you know, the 1.5 million is gonna be gone, and that person's gonna be coming forward, and it's gonna be, nope, sorry, we're out of money. But who did get the money?
Right.
Now, you know, I'm down here to dancing on the head of a pin, and I am the victim of the last case we had, but I ask, you know, is there not a difference between the other opinion where we said, go forward, and this opinion?
I would say that the exception that Gray is asking to apply is a broader exception than the one that was kind of created, I would say, in that opinion, which is opinion 20-9 for those following at home. In opinion 20-9, which we in-house just refer to as the Water Management District opinion, the exception that Gray wanted to apply was not applicable. So what the board did instead, and if you recall, there were two drafts. There was an A draft and a B draft.
Yep.
In what we were calling then the B draft, we proposed and you adopted a set of criteria that would stand in the place for a much more narrow exception than the one that Gray is seeking to apply here, because the one that Gray is seeking to apply here was not available to, we couldn't recommend that to be available to the Commissioner of the Water Management District. So you created a set of criteria that the funds need to be inexhaustible. That was one of them, that was the main one, but there
Mr.
were
Chairman.
other criteria there.
But if we applied the same set of specific criteria to this case, then it would be the same, would it not?
What we're recommending is that the broader exception is applicable because, unlike the Water Management District opinion, the commissioner here has no role in it, where in that program, they set up all the terms so that maybe, your main concern at that time was they set up the program maybe to make themselves eligible for what was a $300,000 reimbursement. And there was a concern that because they had set the terms, that you had made these narrow criteria to say, it's going to be okay under this, where it's not exhaustible, everybody's going to be able to apply, et cetera, et cetera. We really see these as two separate exceptions. One very narrow that we had never applied before, we may not apply ever again because of how narrow the circumstance is. This being different because, unlike that one, the commissioner has no role in setting it up, administering it, making decisions.
Thank you.
Further question, Commissioner.
But Attorney, you say there's no difference. But for the commission approving the funds, there wouldn't be no program, am I correct? Can you run the program, Mr. City Manager, without money?
Morning, Mr. Chair, Cale Curtis, City Manager. The question is,
Can you run the program in question without money, without funds?
no, sir.
Where do those funds come from?
They originally came from ARPA funds.
Well,
American
let
Rescue Plan Act
me back up. Who approves those funds to be for the program?
City Commission approved.
Okay. Who approves your hiring and to be the city manager?
City Commission.
Okay. Without those funds the city commission approved, could you run this program?
No, sir.
So is there a role that the city commission is playing to make this program possible?
Yes, they approved the funds for the program.
Thank you. So when you say, Mr. our council, I'm talking to the council now, when you say that they don't have no role, I'm confused. Because but for the money, there wouldn't be no applications, there wouldn't be no commissioner asking to get a benefit of getting her home or whatever redone with taxpayer money because she approved it. And for us having more funds, I think the city attorney just said the money runs out, they can vote to put more in there. So I don't understand when you say they have no role. I mean, I'm confused. You have to explain that to me.
In our past opinions, we not considered the allocation of funds by a governing board to be part of that involvement, I don't think, because, but you'd be welcome to do that if you wanted to.
But to the council, my problem with this, the reason we get hit here, the reason we have these problems and we have these conflicts is because of money. It's always money. And but for the money, it wouldn't be a program, wouldn't even be asking for an exception to a conflict of interest. The conflict is you got an elected official voting for funds for a program in which they're gonna benefit from. That's a conflict.
Commissioner, I don't know if this will address your concern or not, but if we were to follow that reasoning through, it would preclude local government bodies from ever setting up wide-open funding programs open to everyone equally in the community based on the potential that they might someday down the road apply. So no general funding programs like this, no grant programs that ever really be able to get off the ground. We would, I think, hamper local government entities in that regard.
The only problem I see is the elected officials benefiting. And that's what's gonna happen. I mean, they vote for this. I mean, why would I not vote for something that I'm gonna be automatically accepted in and get my home redone at the expense of the taxpayers who are already paying my public salary and I'm getting funds from? Why would I not do that? So yes, I have a role in it. Also, I get to hire the city manager, so he works at the behest of me. So if I don't get my application approved, I'm gonna feel some kind of way when his contract comes up. See, so these individuals have a lot of power and public trust, but for them being elected officials. So when they're sitting there approving money, even when I was in the legislature, we do appropriation, they always ask, is there anyone related to me or that I'm married to or whatever that's gonna receive any of these funds? And if the answer is yes, you have to disclose that conflict. That's a conflict, and it's always about money. So to say that someone set their head, role in setting the program up and making rules and exceptions, and then say that someone didn't, they just approved the money for it, this wasn't the same. Without the money, it wouldn't be any conflict. It wouldn't even be standing here, but for the money. That's what I'm kind of confused on. And then we're sitting here making exceptions to the rule, which is setting new precedents, because now the person come next going to say, hey, you let them do it. They sat there and approved the funds. I didn't design it, but I just approved the money, so I should be able to get my house redone, you know, at the taxpayer's expense, automatically.
I don't know if this will alleviate your concern or not, Commissioner, and I know that Mr. Tolsis wants to address you as well. I would just emphasize again, this is not a program that was limited to certain areas of the city where she lived or certain types of buildings that she owned. It did not set up a program where she was involved in the process. Also, it did not give the city manager any criteria to weigh where she could put her thumb on him and sway it one way or the other. This is a general program open to everyone. She has no public role in it, and the approval of the applications is automatic. So it really is not going to benefit her to insert herself into the process. I understand your concerns, but I just want to emphasize that's why we are recommending that we apply this exception, which is in our laws for situations such as this, in section 112.316.
To your own words, you just said it again. She has no role in it. She has no role in it. I just heard from the city manager that they approved the funds. But for the funds, there'll be no program. So tell me what role she doesn't have in it. That's what I'm getting,
Well, the approval of the
by.
funds would be a voting conflict. The funds were approved from the federal government, I believe, last April, which they can correct me if I'm wrong, but I think at that time they didn't even know what programs they were going to be allocating the funds towards. And then she did vote, you're correct, in October to set up the property improvement program. Technically speaking, that is not a voting conflict, though. She was not voting on her own application. Now, I think you can make an argument here that, she knew that her application down the road would be automatically approved and that she was going to be applying for the program. I can understand where that would give you some pause, but given the fact that this program is equally open to everyone in the community, the size of the class exception of the voting conflict law would alleviate that conflict, in my opinion.
Well, I know we'll go back and forth all day, because I sat up here and I sat there, and I know what's supposed to be done. However, I'm not talking about a voting conflict. I'm talking about a conflict of interest. Conflict of interest, let's be clear. And when you say, and I keep hearing it over and over and over, the selected official who's voting to appropriate these funds has no role. That just blows me away, and no one can explain that to me, how they have no role. Now, if she didn't vote or she recused herself because she was gonna subsequently submit for an automatic program, I'd be okay with that. But that didn't happen, did it?
I know that Mr. Tolsis wanted to address the commission as well. I don't want to.
Yes.
Thank you for your indulgence. Yet, I would just say the request came from the commissioner for this ethics opinion because she was seeking to participate in a program that was open to all 50, there are 59,000 people approximately in the city of Margate, so all the property owners there. Her application was submitted on the condition that she obtain a favorable opinion from the Commission on Ethics. The process that was created provides for the approval of these applications, and then it's up to the homeowner to go through the process to make the improvements, to expend their own funds, and then submit for reimbursement. These funds are from the federal government, so they're not technically, City of Margate ad valorem taxes that are being expended. But I recognize your concerns. The commissioner recognized their concerns, and that's why we're here today. But I do think that similar to the Water Management District opinion that your general counsel cited, I think the breadth of the class is broad enough where there is no specific private benefit with respect to her voting, that she shouldn't be prohibited from participating in programs that are available to all residents of the city, and the commission itself is not taking any specific action on any specific program application, including hers. So much like any other city program where they're allocating funds, as a citizen of the city of Margate, the Code of Ethics does recognize that exception under 316 to allow her to participate. So once again, on behalf
I
of
have
this,
a question for you. How many commissioners do you represent on that council?
how many commissioners do I
Yes,
represent?
you're the city attorney, right?
There are
How
five.
many,
There are 5 city commissioners.
How many?
5.
How many of them applied for this program, automatic exception?
I'm only aware of one submitting an application.
One.
Yes.
And as to the thing about federal tax dollars versus local tax dollars, isn't that all taxpayer money?
It is all taxpayer.
Okay,
money,
that's
yes,
what I was going with that.
I understand.
So my question is, so if the program, you just said, I want to be clear, I don't want to misquote you. The program runs out of money, this same individual that's receiving this benefit can vote to increase the funds?
Well, I think that would be a different case than what happened back in October, because I think there may be, we'd have to look at it. There may be, if another vote came up for allocating additional funds, there may be a difference because of the fact that she had submitted an application already. So that may be different.
Thank you, Mr. Chair.
Commissioner Moore?
Yeah. My concern here is our creating precedents to how we
Elected officials.
A question for the city manager, I guess. When you developed the proposal for $1.5 million funding, was there a process that ascertained the maximum or the gross amount of potential applicants that would come in? You do have a per applicant limit, but did you do an assessment of the community and go, this is the most amount that we potentially would have here? Or is that an unknown?
That's really an unknown. We received a limited amount of funds from the federal government, around $10 million for this program. We're trying to diversify those funds across a broad range of programs for the residents, this being one of them. $1.5 million was a number that we chose at $10,000 per maximum per residential household, or $50,000 for commercial. Yes, there was a limited number of applicants that we could receive for that.
You don't know what that might be?
We made an assumption if you know, all applicants came in from the residential side, you're looking at 150 applications that would come in. Not all of them reached that $10,000 limit. You know, there are a variety of projects that fell well below that. So I think we ended up closing off the applications at around 220.
Commissioner Waldman?
Thank you, Mr. Chair. Well, first I want to just start off by saying I used to represent the city of Margate when I was in the legislature. It's a very well-run city. I do know Commissioner Schwartz, and I understand, of course, this program would be open to all of the members of the commission as well. But if I followed the logic of what, to its logical, I shouldn't say logic, to its logical conclusion, what Commissioner Newton was saying, if you had a bus program, and I was the commissioner and I wanted to get on the bus, I couldn't get on the bus because I voted for that bus program to be in existence. I can't use what it is that I, as a commissioner, I'm supposed to do. I also was a city commissioner as well before I was a state legislator. And so when I look at that, I say, just because you become an elected official and you have a role in these things doesn't mean you don't participate in your city. And I believe what you said, Steve, or Gray, I mean, there are exceptions that we have to allow that to happen, and that's really what should be done. This program, of course, being funded by the feds, is a little different than a bus program. In fact, I look at it as even more remote than a bus program, a shuttle bus program. So I would say if she's treated differently, which I believe also in the opinion, if she's treated differently because of this, then in that case, there is that disproportionate benefit. And then we have the issue that we faced earlier regarding the vaccine. So here we're going and we're looking at it and saying, she has every right, and of course, when I say she, I should say every member of the city commission has that right to apply and get the money. And if the program runs out, it runs out. If I get on the bus, or if I look to get on the bus and it's full and I can't get on the bus, what do we have to do? We got to get another bus? No, you can't get on it. It's done. The bus is full. So you wait for the next one and you do whatever if that comes up. I see that as the same way here. This is just makes sense that there ought to be that process put in place to make sure that everybody's treated equally, and she certainly, or any other elected official, because this would apply as well and probably in another city, that they have that right to utilize the programs that are implemented.
Commissioner Meggs?
I feel so neglected over here on this side. I've been trying to get in for about 30 minutes. I've almost forgotten my point I wanted to make, but I will write this. The only problem I see with this opinion is this is a first come, first serve. And I believe this commissioner might have kind of inside information that would cause her to get in first to get this grant. Is there any way we can write something in this opinion that says, that deals with that issue, Gray? That's my only problem with your opinion. I understand everything except the funds are going to run out. She knew the funds were available. Not everybody in the city probably knew these funds were available. So she's in first come, first served.
My understanding, and maybe the city attorney can correct me if I'm wrong here, the program was approved in October of last year. In November, around Thanksgiving time, I got a call first from Mr. Tolsis and later from Commissioner Schwartz, wondering if she could apply to the program. So it wasn't like she jumped the gun as soon as the program started. Now, I think sometime between November and December, when she requested the opinion, she may have turned in her application. But I don't believe, and maybe these gentlemen can correct me if I'm wrong, that she jumped in right away as soon as the program was started. I mean, there was a period of weeks that elapsed before she submitted her application, during which other people could apply ahead of her.
I'm not sure the timing between when the program commenced and when she submitted her application. It's my understanding that her application was not the first one, and it was specifically not processed because of this process that we're going through.
And are you going to run out of funds?
So as of right now, we've closed off the applications, because yes, we were reaching that $1.5 million mark, and we didn't want to bring in additional applications and have to say, deny them for that fact. We have had to deny a number of applications because they're ineligible, they didn't submit the proper information. Of the $1.5 million allocated, we're at around $1.4 million that is currently allocated and approved for applications. So we have about $100,000 left over that we intend on reopening the program to allocate those funds for future applications.
Commissioner Newton?
Yeah, my question was to the city attorney. This is federal, you say this is federal tax money that came in, right?
Yeah,
So it's one-time money. It's not reoccurring. You won't get it every year. It's one-time money.
Correct. This is through the American Rescue Plan Act to help revitalize communities that were impacted as a result of COVID.
Right. So from all this COVID money that came down from the federal government, these programs were created to expand that money. Is that correct?
The city was allocated about $10 million,
COVID.
and out of that money, so far, it's my understanding, this 1.5 came out of that. And there
Okay.
may be other allocations made for other programs.
Okay.
City manager can talk to that better than I probably.
As to the bus scenario my colleague brought up, do anyone have to pay to be into this program? I mean, is it automatic, or you have to pay some money? Is there any skin in the game
For
for
this
this program?
reimbursement program?
Yes.
There's no cost involved to apply.
So there's no cost?
No.
Yeah, because I think you have to pay to ride the bus, but I want to make sure that we're on apples to apples. And my last question is, it was stated that her application is in whole, and the city manager just said they had $100,000 left. Is her application in that money that's already been earmarked, or is it waiting for that $100,000?
So her application's in that money that's been earmarked, but we have not reviewed or processed her application for approval yet.
So it's already counted in that
It's counted
batch
in the
of
1.5.
we're not going to miss the boat because we got $100,000 left.
Yes, sir.
Thank you.
All right, are there any further questions or comments from commissioners? None appearing. Is there a motion?
I move adoption of the opinion.
All right, Commissioner Walbon, is there a second?
I would second. Second.
Commissioner Meggs? Any discussion?
Discussion.
Okay.
I clearly can't support this for obvious reasons. You got elected officials approving funds. I don't care where they came from, it's tax money from taxpayers. If you know the makeup, Florida's a donor state. So Florida contributes more tax to the federal government than anybody. So to have individuals sit there and approve funds for a program and then subsequently benefit off of those funds, it's a clear conflict of interest.
All right, further comments? All in favor, say
Can I ask
aye.
a question?
Excuse me.
Sorry.
Wait a minute, excuse me.
I'm so sorry. I was a little slow. I'm sorry. I was just wondering if there was opposition to the opinion, which there may not be other than what Commissioner Newsom just indicated, if we were going to give direction to council as to, are we following water management opinion? Or what all is the alternative analysis that we were going to give? But having not heard that, it may not be necessary to even answer that question.
No, well, Mr. Chair, I would actually second that, I thought, where I think we should give a little bit more clarity and really make it as narrow as humanly possible, because hearing that the program has already closed and the funds have, so I guess this is a question for the city manager. Program has closed. Was there any applications that came in afterwards that were denied due to the fact that the funds have been allocated already?
No, sir.
So when you close it, no one else actually tried to apply?
Correct.
Okay.
But if I can follow up on that, if I heard you correctly, by virtue of closing it, anybody else who came to you and said, hey, I heard about this, they're out.
Correct, yep. What we have shared is that if through the review process, if applications are denied and funds become available, we would open it back up, and that is the intent.
Okay, question. Commissioner Ankers, was that a motion?
No.
Okay.
You can second my thoughts, though. I like that idea. You can vote unanimously for all my thoughts.
Commissioner Moore?
Yeah, I just have some clarity on this for me is that the difference between funding a bus or a shuttle bus and specific dollars going directly to someone for the improvement of their property, to me is very different. There's a communal use to me of that bus, and it's open and available to everyone. But the perception of dollars going directly into the pockets of a voting member of a city commission is troubling for me, and for that, I would oppose this.
Okay. Further discussion? All
Yeah,
right.
I'm also, Mr. Chairman, I'd just like to put it on the record, I would also reject this opinion as well. I think the fact that they're earmarking dollars for an elected official and closing it out, as one of the other commissioners mentioned, where if someone wanted to apply, now they're restricted of doing so. I think it's unfair, and I think, yeah, I'm going to vote against this.
Okay. Further discussion? All right, it is before us. Let's call the roll.
All right.
Yes.
No. No.
No.
Yes.
Yes.
No.
No.
Yes.
Okay. Thank you very much.
Mr. Chair.
Is that a dog?
So at this point, though, we have to do something with the opinion. So I guess, now I'm not sure really what it is we're supposed to do. If we don't agree with that opinion, then we have to say that, yes, there is a voting conflict. And so I would imagine somebody would need to make a motion to,
Well, I think the thing to do would be to direct legal staff to bring it back to us at the next commission.
If I may,
Yes.
Mr. Chair, I think we have Gray and I were whispering in the background while the discussion was going on. I think we have a proposal that maybe might be able to, an edit that we could do that might help with some of the concerns that we can make pending your adoption today. There's a footnote that I think we could add where obviously there's a problem with, we're seeing that there's a problem with the fact that this particular program is closed off. That's not a fact that we had in here. We would propose potentially adding that fact and then mentioning that any vote to extend the program because she's got a pending application would be a voting conflict, would potentially be a voting conflict for her to extend the program while she's got a pending application.
Mr. Chairman.
You recognize?
But, Mr. General Counsel, a vote to extend the program wouldn't provide a benefit to this commissioner because this commissioner is already in the 1.5 billion.
Correct.
So a vote to expand or extend the program would seem to me to be not a conflict of interest. Is that not correct? Why would it be a conflict of interest
I
to?
think I know it, yeah. No, I understand now. Thank you.
So are you saying that you wish to, in view of the discussion and the vote today, which rejects the opinion, that you want to come back at a future commission meeting with a different opinion or a revised opinion? Is that what you're suggesting?
That would be our option. We would come back, and I suppose we would, it sounds like the commission is pretty clear. It views this as a prohibited conflict of interest. I think that we would draft the opinion that way.
Okay. Thank you.
I have a question.
Commissioner Newton.
I would make that broader and say none of the commission, if they vote and choose to participate, would it be a conflict? Because she's already in. You just heard he had 1.4 million, she's in. But if they vote to extend it, then the other 4 might want to get their homes done. You follow me? So because they let her do it, now they're going to be able to do it.
The only-
So you set a precedence, is what everybody was talking about that we were doing up here. Voting to extend the program will allow the other 4 commissioners to participate.
My concern might be standing. You know, we don't have standing to issue an opinion to the other 4 commissioners, just this particular commissioner has asked for the opinion. So under our rules, we would only be able to issue an opinion to her unless the other 4 commissioners decided to jump on board.
I understand, but let me ask the question of my legal counsel. If this commission, what's left of it, that has not already been included in that 1.4 million and pending this 5-4 vote, vote to expand it, they'll be able to participate? Would they be able to participate because of this one commission already was able to participate automatically?
Before this discussion today, I would have said yes, because the vote would not be a voting conflict because of the size of class of people affected by the vote is sufficiently large that we couldn't say that their gain on this would be special, right? On the conflict of interest itself, we have always looked at the funding of the program without setting up any criteria for what the program looks like to be different from what happened in the Water Management District, where they not only funded the program, they said, with this funding, the funding of the program will be a program that looks exactly like this. We know right away whether or not we're going to be eligible for this or not. What happened here is they funded a program and then said, this is the goal of the program, please set this program up. And they didn't design the program themselves here. We saw those things as being different, and we would have drawn a distinction here on the staff.
Well, I know you can't put a future order, and you just said that. My problem with that was that, see, money don't lie, people lie. Money always tell the truth. Because $10 is $10. It's not $8.75, it's not $9.50, it's $10. Because if it's $9.50, then 50 cents went somewhere, and that 50 cents will tell you what happened. So money always tells the truth. As to the 4 commissioners that are left, if they choose to participate in a future program that they spend funds in, would they have to come back before us to get a waiver of conflict of interest so they can enjoy the money that they just voted for the program?
The law doesn't require anybody to come before us before they act, and we wouldn't be able to force them to do that. Now, as far as getting a binding opinion that protects them, if they wanted to do that, they'd be welcome to, but they don't, nobody has to come before us.
Mr. Chair?
Yes.
It was just the opinion that brought them here. Well, let me reiterate that. If they approve money in the future, would they be required, or would they have to, or could they seek an opinion of conflict of interest, just like their counterpart did, and get their home fixed up also?
We would welcome anybody's request for an opinion at the staff level, if somebody requested an opinion, of course, we would give them a guidance or bring them before you to get them guidance, depending upon our well-established criteria for bringing you formal opinions or rendering that guidance informally. Obviously, we thought with a situation like this, it required formal guidance. Looks like we are now vindicated in that decision.
So your counsel to me is that this day, we didn't create a precedence by allowing elected officials to vote for money that they're going to subsequently benefit from, setting a precedent?
Until we actually render an opinion, which we're going to do next time, anybody who comes to us in the interim with a fact scenario that looks like this, I think we're going to put the guidance for them on hold. We're going to bring you a new opinion next time, it looks like, with a different result. And once you approve that, of course will be something that we look to in our future guidance giving.
So there'll be no floodgate as a tool of elected officials using this to fund their cities by proving money that they're going to benefit from subsequently.
I suspect that the next opinion that we issue on this will create a scenario where we might get more opinions that kind of flesh out exactly what the boundaries of it are.
Mr. Chair?
Yes.
Thank you, Mr. Chair. My understanding is the opinions that we give here don't just apply to city commissions, they apply to boards as well as, I think, the legislature. So, once again, if I follow to its logical conclusion what Commissioner Newton is saying, when the state of Florida initiates programs, let's say for solar energy, and every year that they budget a certain amount of money, and that money can run out. And if that money runs out, nobody else gets it. But that legislator who voted in favor of that program and of allocating funds to it cannot apply, if I follow what you're saying, cannot apply for that program because they were a member of the body that came up with this idea to fund the program, and now it's a conflict of interest, or it's, well, whatever we call this, a conflict of interest or an unjust benefit or anything like that. That's where it falls. Because, Commissioner, while you were state legislator, you voted for many programs that many other legislators, maybe not you, but many other legislators participated in those programs, whether it would be a voucher program or solar energy or anything else that the legislature does. And I think we're going down a very slippery slope, not giving this opinion that we have a problem. And I don't want to go back and forth, Commissioner. I know you're where your position is on it, but I'm following it to its logical conclusion.
Yes.
That's really where we get to.
Mr. Chairman, a parliamentary inquiry.
Yes.
Since I voted in the negative, may I offer a motion to reconsider the vote by which the previous action was taken?
Certainly.
I offer such motion.
Okay. I don't know what the rules are here, but in the legislature it doesn't require a second.
Yeah.
And so therefore, Mr. Chairman, we would vote again. We would vote on the motion to reconsider, would we not? And if the motion to reconsider passes, we'd re-vote on this matter. Is that correct?
That is correct.
Thank you.
All in favor of the motion to reconsider, say aye.
Aye.
All opposed, like sign. All right, show that adopted, so now that takes us back to re-voting on the original motion. Are there comments before we call for the question?
Yeah, I have I'll let him go first.
Commissioner Cervantes.
My problem remains the exhaustion of the funds to the exclusion of people other than the commissioner who voted to put those funds in place.
Exactly.
And that, to me, is the distinction with this other case that I was not privy to. That problem remains to me.
Okay, further questions?
Mr. Chairman, the reason for my motion to reconsider was to give the commission an opportunity to give guidance to General Counsel and to Gray as they may bring this matter back before us. With all respect, I don't associate myself with the comments and the position of Commissioner Newton on this matter, but I do share the concerns of others who are concerned with the fact that this is a program that runs out of money, has run out of money, is running out of money very quickly, and therefore there will be people, arguably, who will be told, no, we're sorry, you can't have this benefit, but as it turns out, a member of the City Commission did get in the group that got the money. So I'm looking for a narrower approach to the opinion that may take into account some of those concerns. I'm not asking if this motion were to if there were a motion that would pass in this matter, I'm not asking that you pass a motion that says I can't get on the bus.
All right, further questions?
Yeah, the comment. And I still stick by that, the clear conflict. The problem with my colleague, his assumptions with legislature and local government, it's 120 members in the legislature and 40 in the Senate, which makes up 160 people. Then there's the governor, CFO, Ag Commission, and Attorney General. So 162 people in charge of 67 counties, 412 cities, and 22 million people. What I'm talking about is the local government. The state creates the counties creates the local government, the 412 cities. When you got 5 individuals voting on money that's gonna benefit them, that's a clear conflict. When you got the state approving a budget to run the whole entire state, that's apples and oranges, that's totally different. And as to the bus argument, like I said before, you can just jump on a bus, you have to pay. Now, if that elected official gets on that bus for free, then he has a benefit. So you can do this all day long. And like I said, the problem is you have elected officials there voting for things that subsequently they're gonna benefit from. And the knowledge that my colleague, Mr. Gates, brings up about the money running out, we in the know. You know, we approve money for a lot of these programs, but what we don't approve money for is marketing. There's no money for marketing. So only the people in that room or the people in person attending that meeting is gonna know about these programs and those funds. So they got first dibs on them. So when it's all committed and then they close it out, now Joe Public or the citywide person that they spoke about can't participate because there's no more funds. But we already earmarked a spot for this elected official that sat there and approved this money.
Commissioner Moore?
The fulcrum for my decision on this is the language again. I go back to page 11 where it says they accommodate all eligible applicants, when in fact they cannot accommodate all eligible applicants. I would think the difference here for establishing precedent, to Commissioner Gates' point, is if we had before us a program that could in fact and would in fact accommodate all eligible applicants, regardless of where they are, being a resident of the community and meeting all other eligible criteria, I would vote in the affirmative here. My problem is that you cannot do that. That they cannot accommodate all eligible applicants, and we end up back here with a case 4 months from now or somebody filing a complaint that a commissioner got preference, and then we're going to have to relitigate that all over again. So that to me is the key point here is, does the program actually, and can it accommodate any and all people in the community that would apply to it? And we know already, in fact, that this one does not and cannot.
Mr. Chairman? Thank you, Mr. Chairman. I would therefore, since the matter is back before us, move that we refer this matter to our legal staff in view particularly of Commissioner Moore's comments, and ask them to prepare a proposed draft opinion for the next meeting.
Is there a second to that?
Second.
Good discussion? Commissioner Waldman?
Thank you, Mr. Chair. Just real quickly, because I can appreciate what you're all saying, but the state, when they implement programs, there are fixed amounts of money that are available. And if more people apply than money is available, those other people will not be eligible. And if that state legislator applies for that program under what is being proposed, or we're leaning towards, that legislator would be violating the code of ethics. I don't agree with Commissioner Newton that the amount of people is different. It doesn't make a difference. Governing is governing, and whomever is doing it doesn't make a difference whether you're one of the 120 in the House, or you're one of 5 on a city commission. And I just wanted to make it clear that the bus program I was talking about was a free bus program, shuttle bus program. It was not a pay for to be able to use the shuttle bus.
Mr. Chair, call the question.
Question's been called. All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. Thank you, gentlemen. Thank you, commissioners, for a very spirited discussion, and we'll look forward to legal counsel being back before us at the next meeting. All right, that takes us now to,
So the motion and the second, they refer to council, doesn't require a vote?
That money was
We did, okay.
we just voted.
All right.
Yeah. Okay, next item is Appeal 22-1001 and 002, both of them Keystone Golden State Strategies Incorporated. They are really one and the same. One deals with the first quarter and one deals with the second quarter. This is an appeal of automatic fines under the executive branch lobbyist registration. They're not related to the lobbyist audit investigations we see every year. Rather, these appeals seek to waive the automatic fines for late quarterly compensation reports, similar to the financial disclosure appeals as routinely we have before us. Section 112.32155D, Florida statutes, assesses an automatic fine of $50 a day on any lobbying firm that fails to timely file an executive branch compensation report. We can waive those in part or in whole for good reason shown, based on unusual circumstances surrounding the failure by the designated filing date not being honored. The maximum fine is $5,000. The appellant did not request a hearing in the appeals before us today. Gray, you are recognized to present the draft orders, after which there'll be discussion and questions, a motion, discussion, and vote.
Thank you, Chair. Commissioners, we don't get too many of these kind of appeals. I think the last one they received was back in 2016. They happen when an executive branch lobbying firm, as the Chair said, fails to timely file a quarterly compensation report. For each day that they're tardy, they get a $50 a day fine, up to a maximum of $5,000 per late report. And once the Commission tabulates the final total of the fine that's going to be imposed based on that late report, it has to give the lobbying firm 30 days to appeal before the fine will be imposed. Most firms just go ahead and pay the fine. They don't file an appeal. But here we did have an appeal. The firm here involved is Keystone Golden Straight Strategies, Inc., and they brought appeals from 2 fines that they accrued based on the filing of comp reports for last year. The first appeal concerns a fine of $5,000 for not timely filing their first quarter comp report in 2022. They filed a timely appeal, so the matter is being presented to you this morning. Now, as the Chair said, in appeals and these kind of fines, the firm has to demonstrate an unusual circumstance that led to the untimely filing, which usually equates to circumstances beyond their control. Here, the lobbying firm has asserted 2 reasons in their appeal of the fine for the first quarter comp report of last year. Their first reason is that they say they performed no lobbying during the first quarter of last year. I would recommend you not find that to be a valid basis to waive the fine, because the law requiring the filing of quarterly comp reports says those reports have to be filed even if it's just to report $0 in compensation. But I would recommend you find the firm's second reason does constitute an unusual circumstance justifying the waiver of the $5,000 fine for the first quarter comp report. The firm is claiming that their administrator, who was the sole employee, I think it's a fairly small firm, it was their sole employee responsible for putting together and filing the comp reports, was hospitalized during the period of time that the form was due, and then died soon after. Since the firm has said this individual was the one solely involved in filing its report, and since his hospitalization and death affected the firm's operations, I would recommend you find there's an unusual circumstance here to waive that first quarter $5,000 fine. And I prepared a draft recommending that to you. Now let me also go ahead and address the firm's second appeal as well. It pertains to a fine of $2,150, which they accrued when they didn't timely file a comp report for the second quarter of last year. They didn't accrue the full $5,000, but they did get a fine of $2,150. Now the reasons for waiving the fine for the second quarter comp report are just the same as those for waiving the first quarter. They were arguing they didn't conduct any lobbying or receive any compensation, but as I've already went over, that's not a valid basis under the law to waive the fine. But they also argued the death of that administrator continued to affect their operations. The administrator actually died during the period of time between which the first and second quarter comp reports were due. And they also argued that it was a relatively small staff. Many of them were experiencing a lot of other health issues, including lung fibrosis, long-term COVID. They just didn't want to bring somebody else in to replace that administrator, given the sickness in their office. So, given the health concerns, but even more predominantly, given the fact that the death of this administrator seems to have continued to affect their operations, I would again recommend you find unusual circumstances to waive that second quarter comp report fine at $2,150. And I will say that they appear to have gotten their feet underneath them again. They did timely file their third quarter comp report for last year. The fourth quarter comp report is not due yet. So I offer these 2 drafts now for your review, and I'm happy to answer your questions.
Okay, are there questions? I will accept a consolidated motion on both.
So moved.
Move we approve the recommendation.
Second.
All in favor, say aye.
Aye.
Opposed, like sign. Okay, Gray, don't go away. The next item is item 8, consideration of final order rescinding financial disclosure. This is a consideration of rescinding the automatic financial disclosure fine previously filed or assessed on Michelle Klingman. Gray, you're recognized to present.
Thank you, Chair. This is essentially a bookkeeping matter. It's very similar to something I presented to you all in December. Ms. Klingman here is an employee of the Miami-Dade County Public Trust, and back in 2017, she was included in the list of financial disclosure filers, and she got several notices to file her 2017 Form 1. She was tardy in filing that form. And because of that, she accrued a fine of $1,500, and back in December of 2019, the commission entered a default final order against her requiring her to pay that amount. Apparently, she entered into a payment plan with the commission, and she has fully paid her $1,500 fine. And that concerns the fine for not timely filing her Form 1. But separate and apart from that, the Ethics Commission self-initiated a complaint against her to see if her failure to file was willful. As you know, if a filer incurs a $1,500 fine for not timely filing their financial disclosure, the commission is required by law to commence a separate willful proceeding to see if their failure to file was willful. Willful proceedings, again, are separate and apart from proceedings about disclosure fines for untimely filings. So that's what happened here. The willful proceeding was separately brought against Ms. Kligman, and during the course of that proceeding, our commission's advocate ran across some information that Ms. Kligman should never have been included on the list of disclosure filers back in 2017, because for that particular year, she didn't have the requisite purchasing authority that would trigger a filing requirement. Now, the commission's advocate verified that with an affidavit from Ms. Kligman's supervisor. She presented that to you during the last meeting, and based on that information, you entered an order dismissing the willful complaint against her for lack of jurisdiction. So that handled the willful proceeding. But we still have out there that $1,500 fine for not timely filing the form, and as it turns out, she wasn't required to file the form in the first place. So what I have before you now is an order asking for you to rescind the default final order against Ms. Kligman, entered back in December of 2019, imposing a $1,500 fine for her untimely filing of a form, which, as it turns out, she wasn't required to file in the first place. So I present that order now for your review. I'm happy to answer your questions.
Okay. Do I hear a motion?
I move council's recommendation.
Second.
Is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. All right, Gray, now you can sit down. Okay, that takes us near the end of our agenda, but we want to consider additional legislative recommendations. As you know, committees have started, and there was a fairly spirited debate in the House this week, and so there may be some additions that we want to make or changes regarding our legislative recommendations, and Carrie, you're recognized for that presentation.
Thank you, Mr. Chair. I'll still have the legislative update towards the end of the meeting, but we agended this item based on comments and instruction you gave in previous meetings where you considered cases and you wanted to perhaps consider adding a couple of items to your legislative recs for 2023.
Why don't you consolidate both your reports?
Okay.
And include this and your legislative update. That would make it a lot easier.
I will do my best. Thank you. So what I'd like to do is sort of take these one at a time, if you would allow me to. The first one relates to those lobbyist audit matters that you see. You have often wanted more flexibility than what the statute has given you in handling those matters. And so in your initial recommendations for 2023, you wanted the ability to be able to dismiss a matter under the Rudd Amendment, which we currently have. So that is currently in your recommendations. Then recently, it was mentioned after a case that you also wanted to add to that the ability to find probable cause with no further action, which of course is a different finding than Rudd. If you choose to move and adopt that recommendation, that would be a very easy thing for us to quickly add to this. They're very interrelated.
Okay. Do I hear a discussion or questions or suggestion?
Second.
Chairman?
Yes.
The first one, I think, it saves the people money in the long term, and I think that's a good idea. I understand the arguments in the second one, but I'm still troubled by that because we saw in that case with the luxurious beachfront house and that it's ripe for abuse under this. I know it's be very difficult to try to come up with, very complex to try to come up with a dollar value, and moving forward on it is a good idea, but I'm still troubled that the potential for abuse under the statutes as they exist is there, and I think we're going to end up with cases before us in the future of people who own luxurious beachfront homes using them for improper purposes. So I'm just bothered by it, but point is taken here, that it is complex and difficult to put a number on those or a limitation on those, but we're going to see it again.
Through the chair?
Yes.
If we might. I look forward to us having a robust discussion on the gift valuation. I'm hoping what we can do is go ahead and square away the executive branch one, and then you all can discuss kind of how you would like for us to handle that gift valuation situation moving forward.
Okay. Does that make you feel better, Commissioner Moore?
So this would just be related to the executive branch, if we could do that one.
Mr. Chairman?
Yes.
Mr. Chairman, if it's in order, I would move to adopt the executive director's recommendation as to the first matter and to include it in our legislative agenda.
Second.
All in favor, say aye.
Aye.
Opposed, like sign. Showed adopted.
Okay, so that was the easy one. I think the other matter is a bit more complicated. You had a bit of consternation with regard to the current statutory valuation of lodging in a personal residence. The statute currently values that at the per diem rate, which is $44 a night. That, because it's tied to the per diem found in 112.061. If you all were to want to address and make recommendations relative to changing what the valuation is of lodging in a personal residence, we of course wouldn't want to try to mess with the per diem rates. It would be something exclusive to 112.3148. The commission in the past has interpreted personal residence to be, of course, one's residence where they live. In cases where the individual rents that property out, the commission, I referenced a case in here, it's based on the customary rental rate as opposed to that $44 amount. The case you alluded to, Commissioner Moore, happened to be someone who had a very large and nice home on the water that was their personal residence, which they did not rent out, and so the valuation, of course, was $44 a night. So whether the person stayed in my personal residence, valued at $44 a night, or stayed in a luxurious beachside home for $44 a night, I think that's where the frustration lies. So then the question to you all to discuss and debate becomes, do you somehow want to create some sort of criteria as to how to value it? Do you want to stick with what is current, or do you want to come up with some other amount that you would deem appropriate to apply across the board for valuation of lodging in a personal residence? Of course, if it's a straight across the board amount, if that's $100, my house or the luxurious beach home, they're going to be two different things. I promise you. I've got two dogs that are going to jump all over you, and teenagers. So it's going to be a whole different experience, but $100 either way. The effect of it in reality would be, under the current law at $44 a night, an individual could stay in someone's home for the weekend, Friday night, Saturday night. The valuation would come in at $88. That's not going to be a reportable or a prohibited gift, unless you're someone subject to the expenditure ban, which is not what we're talking about here. If you were to raise that amount to $100, then a person could, of course, stay one night and not have a prohibited or reportable gift. But if you went, if they stayed 2 nights, they'd be in a position, as they are with other gifts they receive, of needing to pay for it so they don't receive a gift, pay it down so it's not reportable or prohibited. So I look forward to your guidance as to whether or not this is an issue you want to discuss and add to this year's recommendations, or how you wish for us to proceed.
Okay?
Mr. Chairman?
It is complicated because,
Well, you,
frankly, you can't stay in a doghouse for $44 a night.
No, I was just thinking that, Mr. Chairman. It's generally, it's a mistake to put a dollar amount in statute. But by the same token, if you use a phrase like customary market value, then we can just imagine the kind of evidence and debates that we would have on that topic if there were a case before us. So, Madam Executive Director, what do you recommend?
Oh, that I wasn't expecting. You know, my recommendation would be at this point, we have a pretty robust list of recommendations, which we've not been successful at moving through the legislature yet. And so my preference would be at this time, given that we are already in committee weeks, is that we perhaps go with what we currently have for 2023, include the additional item that you've added related to executive branch lobbying. And then maybe we can schedule some sort of discussion or workshop of this particular item at a later meeting or meetings where you could have time to give it some thought and robust discussion. And if we were going to put it on an actual list of recommendations, we would put that on in ample time to start working that, and maybe we'll get some wins this session on some other matters.
I have a question.
Commissioner Newton.
How do we get to the $44? Do you know that?
Through the chair.
What's the history? Yeah.
The $44 is the per diem rate
Understand,
that's
but
under
is-
the travel, so it's subtracting, thank you for asking me to clarify. It's subtracting the meal allowances.
Whoever you are down there.
Since our executive director says she has 2 dogs, I make a motion that we let sleeping dogs lie.
Right.
Second.
My wife would agree with that.
All right, I think we have some understanding on that.
All right.
And tell us what happened in the House this week and kind of where we are in terms of what we have submitted. We had a very robust hearing in the House a couple of days ago, and after much discussion, the bill was voted out and it's on its way. However, there is no companion in the Senate at this time.
That is correct. Thank you, Mr. Chair. On Wednesday afternoon, proposed committee substitute for House Bill 37 was considered by the House Ethics Committee. It was initially sponsored by Representative Roach. He did a fantastic job of presenting the issue of enhanced financial disclosure. This has been your recommendation, this commission's recommendation. I looked back since at least 2015. We got really close last year and didn't get across the finish line. Representative Roach is committed to this idea. He included your recommendation of a Form 6 being filed as opposed to a Form 1 for city commissioners and mayors. So that is cleanly included in the bill, where, and that is without any sort of fluctuating standard, which was your recommendation. Where there was a lot of question and debate was that he also included in the bill that city managers and county managers would also be required to file a Form 6 as opposed to a Form 1. That was not a part of your recommendation. Representative Roach asked me to appear and speak, and I did. I spoke on your behalf in support of this bill. I did indicate, however, that the commission had not taken a position on the matter of city-county managers, that was not a part of your recommendation yet. So I wanted to bring this to you today because I think your opinion matters to the members of the legislature, and specifically the members of the committee were interested in that, and see if you were inclined to take a position with regard to city-county managers, whether you wish to take no position at all, or whether you were opposed to that idea. Some of the discussion led to city-county managers would be the first employees being required to take a Form 6 and complete it. Obviously, they have a lot of authority at the city and county level, which led to a discussion of the members of the committee of all the various positions in government who are employees who have a lot of authority, and whether or not those folks should be required to file a Form 6. So, you know, Representative Roach is very passionate about this. I think he stated he would go for Form 6s across the board for everyone. And so it's wonderful to see him passionate on this particular subject. I look forward to your guidance as to how you wish me to represent your interests before the legislature.
Well, it would be my recommendation that we approve that. And there are a lot of reasons why. We've made a decision, or the legislature, if they pass the bill, will have made a decision to extend more stringent filing requirements to the city and county level, and to require the chief executors of those various organizations would not be inconsistent with what's all over the statutes already dealing with state agencies. It is not uncommon where there are requirements of elected officials doing certain things, or appointed officials doing certain things, and the executives who carry out their directions being required to do the same thing. So I think it would be consistent with the state level if we did this at the city and county level.
Mr. Chairman, a question.
Yes.
The bill that was voted out of committee, did that include the city and county managers?
Through the chair, yes, Commissioner Gates, it did include city and county managers, with some members indicating that they wanted to see that taken out along the committee process, so there could be activity related to that.
Thank you.
Is there a recommendation or motion?
I move that we do exactly what this means, that we approve that.
Okay, is there a second?
Second.
All in favor, say aye.
Aye.
Opposed, like sign. Okay?
Okay. One more item of legislative interest. Wanted to let you know there are a couple of other bills in the House, 199 and 241. Both of them seek to remove an exemption under the 112.313 sub 7A, conflict of interest, conflicting employment contractual relationships, seek to remove an exemption relating to certain special independent taxing districts. In addition to that, in House Bill 241, they're adding special district board members to the 4-hour ethics training requirement. None of these bills have companions in the Senate, but I will tell you that I'm hopeful, particularly for the enhanced financial disclosure filing, that we'll get to see something in the Senate this year. And so that wraps up my legislative report.
Okay, thank you. All right, let's move into consideration of the lease. Bring us up to date as to where we are there.
Okay, so I am excited to speak to the memorandum that was in your materials. Steve and I, at your direction, did enter into some negotiations with the landlord on our current property lease, and have some proposed terms before you. As you know, my expenditure authority is very limited, and so what I'll be looking for today is hopefully a motion authorizing me to enter into a lease and expend certain funds. We've been in this building since about 2013 under the original lease and the renewal that was exercised and approved by this board. The building suits our needs. We occupy the second floor of the building, the entire second floor. It works very well for us. The office park maintenance is responsive. The landlord wants to keep us, given our responsibilities that are coming up in the expiration of the lease at the end of June. We would really like to stay. As a part of the negotiations, the landlord has agreed to provisions for some build-outs if we need new employees, as well as some lighting improvements which have already been done. The right of first refusal on the empty space that is on the first floor of the building if we need to grow. They also agreed that we could put a camera and a phone line down at the elevator on the first floors for some increased security, which was a concern you all had raised when we first brought this up. We did check the DMS rates for other agencies. I indicated that in the memo to you. We currently pay $17.75 a square foot. We have 5,509 square feet. in our current space. This is very competitive with what other state agencies are doing in private space. Under the new terms that are being proposed, we would do a 6-year lease. Would begin July 1 of this year. They would reduce our rate to $17.50 a square foot for that first year. It would call for a 50-cent per square foot increase each year, with the 5th and 6th years, both years remaining at $19.50. Currently, the state rate for its tenants is $17.18, and the state agency private lease space in Tallahassee averages $21 a square foot. We also have a provision potentially agreed upon of a renewal, 4-year renewal allowed for. It would be a standard DMS lease. All of the other terms would remain the same as our existing lease.
Mr. Chairman, I have a motion.
Yes.
Mr. Chairman, I move the executive director's recommendation and accompanying financial outlay authority.
Second.
It's been moved and seconded. Is there a question, questions or discussion? Commissioner Moore?
The issue of, I raised the issue prior about security of the building. Are you comfortable with the camera and phone installations, whatever you say, at the first floor level? Would it be result in a locked elevator and then you'd have to be approved to go up?
Through the chair, yes, that would be what we contemplate. We do have control to lock our elevator, and staff has fobs to move in and out. It unlocks in the morning at 8, it locks at 5. You can't fob up. We could lock it during the day and have a camera and a phone so that we could fob people up and down.
And there are no additional floors to the building. So this effectively gives us total private security for the second floor, because anyone using the elevator would be using it for the purpose of coming to our office. So the ability to have a call button, a lockdown, whatever, is not going to inconvenience anybody else in the building, and it gives us very good security. Okay, that's
Did
taken
we
care
take
of.
a vote? Did they vote? We had a first and a second. Do we have a
Oh,
vote?
yeah. All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. We are required by law to give the legislature an annual report. We have done that. The draft is in the materials that have been circulated to you. I have also, and I don't think it's in your material, but I have also prepared my chairman's report. That is not required to be sent to the legislature. And that's my report, where what we have before us is the commission's report to the legislature. I know you've had a chance, as I have, to read it. Do I hear a motion that we adopt the commission report that has been prepared very excellently, I might add, by staff?
So moved.
All in favor, say aye.
Aye.
Opposed, like sign. That takes us reluctantly to the next item on the agenda. We elect a chairman and vice chairman on an annual basis. I have thoroughly enjoyed being your chairman this last year. Carrie and all the rest of the staff are delightful people to work with, and I did not realize how much required time would be involved with being chairman, but I have enjoyed every minute of it, and as I say, I reluctantly hand the gavel over to whoever you may select, who will become the chairman and the vice chairman at our next meeting in February. So do I hear a motion on the election of a chairman?
Mr. Chair.
If there's none appearing, I'll just stay.
I'd like to nominate Commissioner Gilson as chair.
All right? Is there a second?
A question. Are
Yes.
you eligible to be reelected? No?
I don't know, but I won't.
Through
That's
through
four
the
out of
chair,
Yeah.
through the chair, by statute, it is a 1-year term
Yeah.
for the chair.
You're out.
Yeah, I'm done. Well, I'm off the commission, I think, in June, along with you and Commissioner Wallman, and I think somebody else. Yeah, so,
Looking for a vote?
anyway, there'll be a turnover this year. Are there other nominations for the office of chairman? All right, All in favor, say aye.
Aye.
All opposed, like sign. All right, show it adopted. Do I hear a motion for selection of a vice chairman?
Mr. Chair, I'd like to nominate the election of Commissioner Gates as vice chair.
All right. Are there additional nominations? All right. All in favor of Commissioner Gates as vice chair, say aye.
Aye.
All opposed, like sign.
My wife?
All right, show it done. Commissioner Gates and I are on another. All right,
Mr. Chair, I'm sorry to see you go, but I look forward to working with Chair Gilzine in the future and
Great.
Vice Chair Gates.
all right.
I noticed that the commission members with the letter G's in their name have this, so I think that's something happening. And wait, we're in order,
I thought it was
too.
merit, but no.
Right,
I see it's not.
yeah, it's definitely,
Yeah, we're on a string.
yeah.
Commissioner, Mr. Chair, may I say one thing?
Yes.
I'm sure we'll have the opportunity to thank you another time, but I did read your annual report introductory letter, and I think that it's interesting and noteworthy for all students of Florida history that you have served since the very beginning, and now, decades later, have served in this role, and I don't think that will be repeated, and I appreciate you doing it at the beginning, the alpha and the omega.
Well, thank you. I've enjoyed the experience.
I would like to.
All right.
Vice Chair Gilzine.
So, yeah, I do want to add that Commissioner Anker stole some of my talking points. She must have leaned over and saw my computer. But yeah, you were first appointed when this commission was elected in 1974 during the regular session of.
I thought Andrew Jackson appointed it.
Oh, thank you. So,
Is it?
wow, we got cameras here.
Yeah, hold on.
Okay, well, congratulations, Chairman Grant. I just want to say you were the first person appointed nearly 50 years ago with the fellow commissioners that began taking the task of writing rules and drafting forms. The newly appointed commission made a recommendation to the legislature about the powers, procedures, and duties of the commission, public discourse, and standard of conduct. By the end of March 1975, 223 requests for advisory opinions and 34 sworn complaints had been received by the commission. Serving 3 terms, was appointed by Governor DeSantis, and previously served both in the House and the Senate. Wow, you have on both sides of the House. That's pretty cool. But more importantly, I just want to say thank you, Chairman Grant, for helping navigate this commission during the historic years and in the launch of the e-filing system. And then we're excited about the legislative session, and as a result in the pause of the e-filing system and then its relaunch. So Commissioner Grant, thank you for your leadership. I appreciate it.
Thank you.
You have 3 of these.
Yeah.
What do they call it in hockey? A hat trick?
Hat trick.
So, congrats.
Well, thank you very much.
Thank you.
Triple crown.
All right. Ah, triple crown. That's what it is. Almost there.
All right, well, there's nothing much more for me to say in my chairman's report. As Commissioner Anker said, I enjoyed writing the report, and it was a unique year. We were breaking in a new administrator. Carrie just has been a gem to work with. She's just an outstanding person, and she has assembled one of the best staffs I know of any government agency in the state of Florida. We've had a turnover on members of the commission. We've welcomed new members. We have launched e-filing, which was second only to the challenges of firing a rocket and hitting the moon. And we got put off for a year. At first, that really concerned us because we were all cocked and primed to go. And it was really kind of a blessing in disguise because it allowed us an opportunity to find some flaws in the system, and they were corrected. The one thing, and I'm going to go back to Carrie when she does her executive report and ask her to flesh it out, but as you know, there is an election. There are more than one elections going on this year at the city level. I think the biggest one probably in Jacksonville. We are, I'm hearing voices somewhere, we are doing very well with e-filing. This has been a good test for us. So it was good to put it off a year, but we're up and running. The flag is up the pole, and we will have a good 2023, and we'll work out any additional flaws that need to be worked out, because 2024, because it's an election year, will be a big year. Carrie, I thank you for doing that.
Thank you, Mr.
And I recognize you now for your executive report, which I have stolen part of.
That's all right. Thank you, Mr. Chair. I think for the first time since I started in this position, I don't have anything to add to my executive director's report. So I'll just ease right into your favorite part, which is the e-filing report. And I don't know what you all were doing, say about 10 o'clock in the morning on January 1st, but we were launching electronic filing, whether you knew it or not. Some of us were busy at our computers making the magic happen and making sure that everything was running smoothly. So we launched officially live around noon, and it was smoother this year and a little bit less stressful than last year. We welcomed our 1,681 agency coordinators into the system. They are currently compiling the list of filers for the 2022 calendar year who will file disclosures due by July 1. There was almost immediately a qualifying period over in Jacksonville. The Jacksonville City Commission does file Form 6s, and so they all, as far as we know, every single person who wanted to qualify to run for office was able to utilize the system and create and file their Form 6 to do that. It is live to filers currently. Any filer who wants to access it can contact the commission if they are a Form 6 filer, get an invitation to register, and start building their form. We anticipate doing our mass noticing to filers, which we normally do in May. We're going to do earlier this year. We're shooting for March, just to give filers some more time in the new system, whether they want to or not, to get in there and get familiar with it. And we're going to encourage them to not wait until the last 2 weeks of June for all of our benefit. It's been smooth. There are still things on the back end that don't look the way we would like them to and don't work the way we would like them to, as with any system, and we are working closely with the tech team to work through those. But it has been smooth. Kim Holmes, our financial disclosure program administrator, presented 2 live webinars for those agency coordinators to be able to get on with us. She walked them through the system. They had a chance to ask questions that were answered live and through the chat. We recorded that webinar. We've made it available to those agency coordinators as they work to certify their lists. So far, about 25 Form 6 disclosures have been filed so far this year. Remember last year when we launched, prior to the pause, there were over 800 forms filed. So we know it can be done, we know it has been done, and the feedback has been good. Other feedback that has been good is that we are currently testing, in user acceptance testing, the document upload feature. That was one of the issues that was raised last year during session as to why the legislatures sought the pause. We demoed that document upload to House and Senate staff of the ethics committees, and the feedback was really positive. They used words like intuitive, which for those of us who have to use systems, it's always good when it's intuitive to the users. So We're going to continue to work on it, address any issues that come up. Also wanted to note that, as has been the case since we started this years ago, we do occasionally have personnel changes that happen from time to time with the tech team. And OLITS, the Office of Legislative Information Technology Services, who is in charge of doing this in-house system, they are currently looking for a new technical team lead. But things are progressing nicely. Hopefully, the update in March will be the same. And so that's all that I have. Thank you.
All right, well, thank you very much. Is there any additional new business or old business? Does anybody want to rediscuss the legal opinion?
No, I do want to say one thing, though.
Yes.
Just want to recognize my family who's in the audience, my Urban League family that's watching online, and to the commission and commission staff, thank you for this opportunity. And my beautiful family is over there, so I know.
Can we stand up?
Probably not, but my nephew, who you probably heard throughout the meeting, now he's quiet, he's all engaged, but love him. I love you guys dearly. Today's your day, so thank you.
Welcome.
I move that they be introduced.
Okay, so I have my mom, mom wave, and then I have my little sister, and then I have my fiance.
Oh, great.
All right.
What is she thinking?
Move to adjourn?
Move to, yes, Phil moved.
Let me make an announcement that we will commence the executive session at 11:05.
Okay.